effect of fortuitous event, diba? So, another important difference between a generic and a specific obligation, indeterminate and determinate, that a specific obligation, that is an obligation to deliver a specific thing. So if it is a specific obligation, the obligation is to deliver a determinate or specific thing. As a rule, extinguished by a fortuitous event or act of God. So once the destruction of a determinate thing, therefore extinguish the if the specific object is destroyed, therefore the specific obligation is extinguished, provided it is extinguished by a fortuitous event. Again, if a fortuitous event or act of God destroys a specific thing, therefore the specific obligation is extinguished. But that is not true with a generic obligation, wherein the generic obligations are never extinguished by fortuitous event. That is genus non quam perit, diba? Genus non quam perit. Genus obligations are never extinguished by fortuitous event. Examples: A is obliged to give B this car. So it means to say a specific thing. This car, because the opposite of that is a car, diba? A is obliged to give B this car. Before delivery, an earthquake destroys completely the car. The obligation to deliver is extinguished already, diba? Fortuitous event or act of God, the example is earthquake, destroy this specific car, or destroys the specific car, so therefore the specific obligation is already extinguished, provided there is no fault on the part of the debtor. Next, A is obliged to give B a book. So a book, it means to say generic, a book, any book. Since this is a generic thing, even if one particular book is lost, other books may take its place. The obligation is not extinguished. Genus non quam perit. Two instances now, those are the general rule. Now, exemption. Two instances where fortuitous event does not exempt, ba? Even though this car, a specific car, is already destroyed by the fortuitous event or act of God or force majeure, diba? Still, the debtor is liable. So what are those? So this is now the third paragraph of Article 1165, wherein if the obligor incurs delay, diba? If the obligor delays, or if the obligor deliver the specific thing to two or more persons who do not have the same interest, so therefore shall be liable in case of fortuitous event. If this time the obligor is guilty of bad faith, for having promised to deliver the same thing to two or more persons who do not have the same interest, as when is not the agent, merely the other, diba? So that is 1165. Ordinary delay versus default, diba? Let us distinguish ordinary delay from a default, wherein ordinary delay, it's merely non-performance at the stipulated time, diba? The mere non-performance at a stipulated time. While default, there is already demand, diba? Whether extrajudicial or judicial. Default is that the delay which amounts to a virtual non-fulfillment of the obligation. As a rule, the general rule is that to put a debtor in default, there must be a demand, either judicial or extrajudicial. What kind of demand? Demand for fulfillment of obligation. When there is no demand, merely non-fulfillment or non-performance of the stipulated at the time of stipulated time. Examples: A is obliged to give B his Jaguar. So A is obliged to give B his Jaguar car on December 7, 2005. If on said day A does not deliver, he is ordinary delay. Tama? Ordinary delay. December 7 is the contract date for the obligation to deliver arise, diba? The arises. December 7 is the contract date, is the stipulated date for the obligation to deliver arises. Now, after December 7, there is only an ordinary delay. Yes, if on December 8, there was already a demand for delivery, therefore, there is already legal delay or default. And if latter the car is destroyed by a fortuitous event, he would still be liable, in that the obligation to deliver the lost specific thing is converted into a monetary claim for damages. So again, when there is already a demand, there will already be a legal delay or default that makes the debtor liable. But when it comes to specific thing is destroyed by a fortuitous event without the fault of the debtor, then there will be monetary claim on the part of the debtor to pay for the amount of the Jaguar. However, if the car is destroyed at any rate, not by fortuitous event, the amount of damage shall be reduced or would be reduced. Now, in the case of the sugar, in case of sugar, in which sugar is lost by a fortuitous event, who bears the loss prior to delivery, the seller or the buyer? The court ruling is the seller bears the loss because prior to delivery, and there is no perfected contract yet of sale because there is lack of segregation, no physical segregation. So therefore, the sugar is one of a class, so a generic, and generic never perish. Genus non quam perit. But the seller bears the loss because there is no perfected contract yet, and the thing to be delivered is not a specific thing. If it is a specific thing, therefore, the seller is not liable. Diba? It's not liable. Now, another case in which A wanted to buy a particular ship from B on condition that B would prove by papers that the B, was the real owner of the ship. Subsequently, the ship was lost by a fortuitous event, although the papers had not yet been produced. So here, A wanted to buy the ship from B on the condition that B will prove by papers that he is the real owner. But subsequently, the ship was destroyed by fortuitous event, and the papers were not yet proved. B did not yet prove that he is the owner. So A is not legally bound to pay because there was no perfected sale. The condition is to show the proof that B is the owner. Since B failed to prove the ownership over the ship, therefore the obligation on the part of A to buy it is not perfected. Note, had already bought the ship. Okay. Diba? In the first case, in the first scenario, A is not legally bound. It's not legally bound because B failed to prove. Failed to prove the ownership. So therefore, A is not legally bound. He's not required to pay for the ship, pay for the value of the ship. Now, A had already bought the ship. Had the proof of ownership been presented earlier, he would have been compelled to pay the purchase price, yes, even if at the time of loss, the thing had not yet been delivered to him, since after all, the sale would have been already perfected. So, prior to the loss of the thing, there is be already prove ownership over the ship. So therefore, the condition is fulfilled. The obligation arises. Or the obligation of A, the obligation of A to pay the purchase price, to pay the value of the ship. So again, the logic behind is that when the condition is fulfilled, the obligation arises. Okay? The condition here is to prove ownership. B should prove ownership over the ship. If he proves it, then therefore, there is the obligation of A to pay the purchase price. But if failed to prove at the time of the loss, then therefore there is no obligation on the part of A to pay the purchase price, or to pay the amount of to pay the value of the ship. Next, A bought property from B on installment. When the first installment fell due, A did not pay. Okay. His defense was that he did not have money and he therefore pleaded impossibility of performance. Is A excused from his obligation? No. No, mere pecuniary inability to pay does not discharge an obligation to pay. No. Or does not it constitute any defense to a decree for specific performance? Yes. Therefore, the obligation shall be demandable, due and demandable already. Then the defense of non-payment because of financial inability to pay is not a valid defense, and also it does not discharge an obligation to pay. Next, Article 1166. The obligation to give a determinate thing includes that of delivering all its accessories, even though they may not have been mentioned. So again, Article 1166, the obligation to deliver a determinate thing, includes all accessions and accessories, even though they may not have been mentioned. So what the obligation to give a determinate thing includes. So what are those, diba? Accessories and accessions. So example, if I am obliged to deliver a particular car, I must also give the accessories, the jack, like the jack. If I am obliged to deliver a piece of land, I must also give the accessions, like a building constructed thereon. This is true even if no mention of them was made in the contract. No, this is true even if no mention of them was made in the contract. So therefore, if you purchase a land with bahay kubo and then it was not mentioned in the contract, therefore it shall be included as an accession or accessories. But if it is expressly stipulated the exemption of the bahay kubo as an accession, diba? It is not included in the contract of sale. It is not part, or it is not considered as an accession or accessory to the parcel of land, then therefore shall respect the tenor of the contract. What's the difference between accessories and accessions? Accessories, those joined to or included with the principal for the latter's better use, perfection or enjoyment. Example, the keys to a house, the dishes in a restaurant. The aim for accessories is for enjoyment, for better use. It only adds, not necessary. Accessory is not that necessary, but it adds entertainment, it adds enjoyment. While accessions, it is an improvement, beneficial improvement, additions to or improvements upon a thing. This includes alluvium, Alluvium, it's a soil gradually deposited by the current of a river on a riverbank. It's a soil, if we are that is in property, wherein an alluvium, it's the soil formation deposited, soil deposited by the current, diba? Soil gradually deposited by the current of a river on a riverbank. These are soil gradually deposited by a river, by a current, deposited by a current river on a riverbank. So that is an alluvium, soil deposited by current river, by the current of the river to the riverbank. And whatever is built, planted, or owns on a person's parcel of land. Note, even if windows of a building have been temporarily removed, they should still be included. So temporarily removed. There is no intention of permanently removing them. Temporarily removed, therefore, that is part of the accession or accessory. Effect of stipulation. Of course, if there is a stipulation to said effect, accessions and accessories do not have to be included. Yes. As a general rule, when what is to be delivered a determinate thing, it shall include all its accessories and accessions, except when there is an express stipulation not to include them. Article 1167. If a person obliged to do something fails to do it, the same shall be executed at his cost. If a person is obliged to do something, fails to do it, the same shall be executed at his cost. Okay. The same rule shall be observed if he does it in contravention of the tenor of the obligation. Furthermore, it may be decreed that what has been poorly done be undone. So this is Article 1167, wherein if a person is obliged to do something, fails to do it, if a person obliged to do it fails to do it, diba? To do something. But if a person is obliged to do something, fails to do it, it shall be executed. The same shall be executed at his own cost. The same rule shall be observed if he does it in contravention to the tenor of the agreement or of the obligation. Furthermore, it may be decreed that what has been poorly done be undone. Okay. Again, Article 1167. If creditor is obliged to do something, fails to do it, the same shall be executed. The same shall be executed at his cost. If the same rule shall be observed. If he does it in contravention to the tenor of the obligation, and furthermore, it may be decreed that what has been poorly done be undone. So this is now the positive personal obligation, diba? Positive personal obligation, wherein the remedies of the creditor if the debtor fails to do it, diba? Again, if a person is obliged to do something, positive personal obligation, fails to do it, the same shall be executed at his cost. Next, if the same rule shall be observed if he does it in contravention to the tenor of the obligations. Furthermore, it may be decreed that what has been poorly done be undone. So remedies of creditor fails to do it: to have the obligation performed by himself or by another at debtor's expense. Only if another can do the performance. Yes. To have the obligation performed by himself or by another person at the expense of the debtor, diba? That's the legal effect. The same is to be executed at his cost, at the expense of the debtor, to have the obligation performed. And next is also to obtain damages. Damages alone cannot substitute the performance if owners can do it. If purely personal or special, as a painting to be done by a reputed artist, only damages may be asked unless substitution is permitted. So the very first is that to have the performance be done by himself or by another person at the expense of the debtor. Next, ask damages. Ask damages also to obtain damages. And damages alone does not substitute the performance. Yes, does not substitute the performance if owners can do it. So, example, a person wants to construct a house. He is not a carpenter. Acquires or hires a carpenter. Then carpenter fails to do it. Fails to construct the house on time. So, the carpenter should construct it at his own cost. Ba? What if the carpenter is already asking for a substitution, not already the performance, not already the carpentry, but also the damages, diba? Once in which, in lieu of his performance in carpentry, he is already giving damages, payment to the creditor, in which he cannot anymore do it. He cannot anymore do it at his own. So he will only just be giving it as a form of damages, or he will be asking for substitution. It is permitted, diba? If a carpentry cannot anymore, is unable to construct the house and ask for a substitution, yes, it can be. But damages alone cannot substitute the performance. So it's useless for an owner to hire a carpenter, and then at certain point the carpenter cannot anymore do the job, and then only pays the damages for delay. These damages alone cannot substitute the performance, diba? Unless only damages may be asked unless substitution is permitted. Take note, specific performance is not a proper remedy in personal positive obligation. This may amount to a violation of involuntary servitude as provided by the Constitution, as prohibited. A party to an agreement to marry who backs out cannot be held liable for crime of slander by deed. Yes. A party to an agreement to marry backs out cannot be held liable for crime for slander. Because the principle in law that what cannot be done directly should not be done indirectly. The same also here in the case of a typewriter owner delivered it to the, this is already what I'm talking about. So let us make it clear. Let us ship the carpenter into the typewriter repair shop. Diba? A typewriter owner delivered the typewriter, the machine, to a typewriter repair shop, Despite repeated demands, no work was done thereon. Eventually, the repairman returned the machine unrepaired and worse, and several parts were missing. Thus, the description cannibalized and unrepaired. So the worse it became. The owner was then constrained to have the typewriter repaired in another shop. So, owner now claims damages from the first repairman for the cost of the repairs and the cost of the missing parts. Defendant repairman, however, alleges that owner should have first filed a petition for the court to fix the period within which the job of repairing was to be finished. So the defense of the repairman is for the typewriter to ask petition from the court to fix the period within which the job of repairing has to be finished. So it means to say the repairman wants a petition from the court to fix the period of time to fix, diba? To repair. So can the defendant be held liable for damages? Yes, obviously yes, because there was no performance at all, diba? The law says that if the person obliges to do something fails to do it, the same shall be executed at his own cost. So therefore, it should be the repairman. It should be on the part of the repairman to make repair at his own cost already. Shall produce the missing parts, diba? And the same also rule shall be observed, diba? Okay, does it in contravention to the owner? In contravention, because the intention of the obligation is to repair, but the repairman worsened it. So that is already in contravention to the tenor of the obligation. Next, the failure of the owner of the shop, or the failure of the owner of the shop to first ask the court for the failure of the owner of the shop to first ask the court fixing the period within which the repair was to be made is of significance. There is no need to go to the court to fix the period for repair. No. Non-performance may be said to have been impliedly admitted when the typewriter was returned unrepaired and with some of its essential parts were missing. So there is already breach of contract for by non-performance. So this is already a breach of contract, diba mo? The same also logic that we're talking about carpentry. There is already breach of contract. Instead of repairing, constructing a house, failed to do it on time, diba? Failed to do it because of unjustifiable reasons. The same here, instead of repairing the typewriter, it became worse. Article 1168, when the obligation consists in not doing and the obligor does what has been forbidden him, it shall also be undone at his expense. So the negative obligation, diba? The negative personal obligation, when what is to be done, or when the obligation consists in not doing, then and the obligor then does what has been forbidden him, it shall also be the same. Now let's go to Article 1169. Those obliged to deliver or to do something incur delay. Those obliged to deliver or to do something incurs delay from the time the obligee judicially or extrajudicially demands from them the fulfillment of their obligation. So as a general rule, those who are in the performance, or those obliged to deliver the thing or to do something, those obliged to deliver or to do something incur delay. Those obliged to deliver or to do something incur delay from the time the obligee judicially or extrajudicially demands from the fulfillment of their obligation. Diba? Incurs already delay. Incur delay. However, the demand by the creditor shall not be necessary in order that delay may exist. Diba? As a general rule, under Article 1169, those obliged to deliver or to do something incur delay from the time the obligee made a judicial or extrajudicial demands from the fulfillment of their obligation. However, demand is not necessary, shall not be necessary in order that delay may exist. These are when the obligation or the law expressly so declares, diba? The obligation or the law expressly so declares. When from the nature and the circumstances of the obligation, it appears that the designation of the time when the thing is to be delivered or the service to be rendered was a controlling motive for the establishment of the contract, or when demand would be useless, as when the obligor has rendered it beyond his power to perform. So, in these cases, there is no need for demand, diba? This is an exemption to the general rule. Those obliged to deliver something or to deliver or to do something incurs delay from the moment or from the time the obligee demand judicially or extrajudicially for the fulfillment of the obligation. The same, as an exemption, there is no need for demand to make a person delay, in which the obligation or law expressly so declares, diba? The obligation of the law expressly declare. When from the nature and the circumstances, from the nature and circumstances of the obligation, it appears that the designation of the time when the thing is to be delivered or the service to be rendered was controlling motive for the establishment of the contract. It's the motive already. The thing to be delivered and the service to be rendered is already a controlling motive as to the establishment of the contract. When demand would be useless, as when the obligor has rendered it beyond his power to perform. In reciprocal obligations, neither party incurs in delay. In reciprocal obligations, neither party incurs in delay. If the other does not comply or is not ready to comply in a proper manner with what is incumbent upon him, from the moment one of the parties fulfills his obligation, delay by the other begins.